The object of Minimum Wages Act 1948. What is the object of Minimum Wage 1948 is to solve the problem relating to minimum living and fair wages in India. So the sum minimum wages 1948, the Minimum Wages Act 1948 is to fix minimum wages in certain employments wherein sweated labor is most prevalent or the laborers are exploited. At the outset, it may be noted that this act aims at removing the difficulties of the employees, particularly in unorganized sector, because in this sector there is a greater fear of exploitation. It is important to note that in regarding the liability to pay the minimum wages, the capacity of the employer need to be considered. The capacity to pay is presumed and there will be no excuse of incapacity to pay. The employer will not be allowed to say so. Crown Aluminium Works versus their workmen 1958 case SC30, it will not lie in the mouth of the employer to say that he will find it difficult to carry on business on such settled principle. It was held in Hydro Engineers Private Limited versus Workmen 1969 case SC182. The Supreme Court in case C Rajiv M and 15 others versus State of Kerala and others 1995, 1991-95 SCC 31 has laid emphasis on enforcing this act in the unorganized industries. The Supreme Court of India has observed that what the act aims at is the statutory fixation of minimum wages with a view to obviating the chances of exploitation of labor. Edward Mills Company Limited versus State of Ajmer 1954. The object of the acts are as follows. Number 8, to ensure that the payments are not as low as to put the laborer at a disadvantage. The wages ensure the payments are not low as to put the laborer at a disadvantage. But that means laborer must not put into disadvantage. Lower wages as low as, so that the laborer thrown into disadvantaged position should not be they should not be thrown into disadvantaged position by giving them a very low wages. This should not be the object. To ensure that payment should be adequate so that they would be in a better position. Wages must correspond to the amount of work done and there should be no exploitation. There must be equitable payment for equitable work and there must not be there would be no exploitation. To see that the unorganized laborer does not suffer from unfair bargaining and their rights are protected. The rights of the laborers must be protected and unfair bargaining must be prohibited. Laborers should not suffer from unfair bargaining. To see that the strikes and lockouts are rooted out by satisfying the laborer through fair payments. That means why strikes and lockouts conducted? Because of the low payment of low wages. So these things are rooted out by satisfying the laborer through fair payments. Through the strikes or lockouts, if their demands are met, if they got the satisfying wages, fair payments, then these kind of provisions provisions are incorporated in the Minimum Wages Act. The act fixes a minimum time rate, minimum piece rate, a guaranteed time rate, and an overtime rate for all the occupations and work. What the act provides, it provides minimum piece rate, minimum time rate, guaranteed time rate, and applies to employment specified in part 1 and part 2 of the schedule, like in Kamani Metals and Alloys Limited and its workmen, which was a case in 1967, Supreme Court 1175. Supreme Court already held that economic position and profit of the industry has no place in fixation of minimum wages. This is not the argument that the company is not able to pay the enough minimum wages. There is no lookout. It is not a lookout of profitability of a company. Is not a reason of fixing of not paying the good wages or fair wages. There must be a minimum wages irrespective of profit. Okay, that applies to the employment specified in part 1 and part 2 of the schedule. The Supreme Court has already told economic position and profit of the industry has no place in fixation of minimum wages, in which case in Kamani Metals and Alloys Limited versus its workmen in 1967 case, the employer cannot raise the plea of economic burden on him, as he is bound to pay by law the minimum wages to his employees. So, economic burden or unprofitability or losses or inability to pay the minimum wages does not alleviate the employer from paying the minimum wages, because as per law he is bound to pay the minimum wages to his employees. The act prohibits the employers to exploit and take undue advantage of the pitiable condition and poverty of the workman. It is mandatory provision and compels the employer to pay the minimum wages. The same view was expressed in the same court in H.D. Singh versus Indian Reserve Bank in 1980, SCC 704, stating the reason the court observed there is a greater possibility that workers may offer and be ready to work on starvation wages in underdeveloped country like ours, which is facing acute problem of unemployment. This is the reason that there is no need to consider the employer's capacity in fixing the minimum wages. So, why in this case of the SD Singh versus Indian Reserve Bank 1980 case, it was reason was stated that there is a greater possibility. What is the possibility? That workers may offer and be ready to work on starvation wages in underdeveloped country like ours, which is facing acute problem of unemployment. Because of the unemployment, starvation wages, the workers are ready to work on a starvation wages. That means all the wages in which they are not adequately not adequately they do not feed their family adequately. That might be the starvation wage. Okay, less than the mm, less than the living wage or very low wages, even lower than the minimum wages. So there is the reason that there is no need to consider the employer's capacity in fixing the minimum wages. Bombay High Court has held that the main important point in consideration in fixing the minimum wages, that in circumstances living wage should be paid and not the capacity of the employer. Arbuda Bhavan versus State of Madras 1991 case. In the case of Soniben Mathurbai Vasawa versus Lalji Hukku Parmar Leather Works Company 1984, 381 Gujarat, it was held that a bare reading of section 17 of Minimum Wages Act shows that piece rated workers are within the scope of the act. So, as per the bare reading of the section 17 of the act, it can be understood that the piece rated workers means the workers who are paid on the basis of the pieces, on the basis of pieces produced or on the basis of piece. So, these kind of workers are included under the act, Minimum Wages Act, as per section 17 of Minimum Wages Act. The act provides for periodical revision of wages fixed, and provision has been made for advisory committee. The provision is made for what? Advisory committee and advisory boards. What they will do, they will represent the employers and workmen both, who shall be consulted for revising the wages. They will act as a mediator, and they will represent both of them, and both the employees and workmen and employers. But as has been said, it is impossible to accept the contention that the minimum wages should conform to the living wages standard. The living wage has to be taken as the standard only in highly industrialized countries or in countries economically advanced. In India, where the level of national income is low and the general economic condition of the country is poor, not to mention the entangled threat to the stability of an unorganized labor, The living wage would remain an ideal to be attained only in progressive stages. Meanwhile, fair wages with the minimum wages as their base will contribute the wage structure. So, living wage would be applicable for the progressive states like developed countries. In India, where the national income is very low, where our most of this part is unorganized sector, most of the country is poor, represent the living wage cannot be has been taken as standard only in highly industrialized countries. In countries who are economically advanced, in India where the level of national income is low, general economic condition is poor, not to mention the entangled threat to the stability of an unorganized labor, living wage would remain an ideal to be attained only in progressive stages. That means it is an ideal when it would be achieved only in progressive stages, when the country will progress. Meanwhile, fair wages with the minimum wages as their base would constitute the wage structure. Supreme Court of India has observed that the object of the act is directed against exploitation of the ignorant. What Supreme Court has observed that the object of the act, what is the act? Minimum Wages Act, is directed against exploitation of the ignorant. So if a person is poor, he don't know about his right, he is ignorant about his right, so exploitation must not be he must not be exploited for the because of the ignorance or because of the absence of knowledge or because of the uneducated or lack of education. So he must not be exploited. So directed against the exploitation. Exploitation must be prohibited. So that's why Supreme Court has observed that the object is that less organized and less privileged members of the society by the capitalist class. So who will exploit? Capitalist class. Exploitation by capitalist class must be prohibited. Who exploitation by the capitalist class must be exploited, like underprivileged members of the society's exploitation must be prohibited. Thus, the anxiety of the state for improving the general economic condition of some of its less favored members appears to be in suppression of the old principle of absolute freedom of contract and doctrine of laissez-faire, and in recognition of new principle of social welfare and common good. Y.A. Mamade versus Authority under Minimum Wages Act AIR 1972, SC 1721-1725. So that's all about this video. Let's conclude this video. If you find it any useful legal insights from this video, please like, share, subscribe my YouTube channel for more such content.